All right, I think we're ready. Ms. Rivers, can you hear me?
Yes, Judge, I can hear you. Good morning.
Good morning. Thanks for joining us. We have, looks like most of our defendants will be appearing from the jail. Don't know who is on, if it's going to be from the sheriff's office. Is there a particular order in which you want us to go, sheriff's office? No. All right, we'll figure it out. That'll make it challenging, but we can do that. Let's turn, there's someone in this booth. Let's turn this one on. Hey, good morning in 4 North. Who are you?
Good morning, sir. My name is Donnell Wharton.
Fantastic, Mr. Wharton. I'm Judge McBurney. You are position 2 on our calendar. Who is handling Mr. Wharton's case?
Good morning, Judge. I will be handling that case.
Great. And I know, Ms. Wood, that you're actually handling every public defender case today. But when you say you're handling it going forward, when Ms. Patel is back, will this still be your case?
Judge, it's my case, and we actually have a negotiated plea ready on this case. And there's an additional case that we waived arraignment on. I can give you that number when ready.
I think I've got it. Ms. Nelson got me all set up today. Is that the one that ends in 996?
Yes, Judge.
Okay. Are you and Mr. Wharton ready to go forward with that?
I had we are ready. I just had one small question about the structure. I sent the ADA a message in the chat. I think if it's Ms. Green that's covering from the chat.
Let's get to know our ADA for the day. Ms. Green, are you there?
Yes, Judge. Good morning. Thank you for letting me be in your courtroom. It's ADA Amanda Green.
No problem. I'm glad that you're filling in. We appreciate it. Ms. Charles is off doing other stuff. Ms. Wood, did you and Ms. Green need to talk? Do you want me to put you in a breakout room, or are you? What do we need to do?
I don't think we need a breakout room. I will send her my question. Amanda, do you have access to the chat?
Yes, I'm seeing it right now.
Okay, I'll just send you a really quick message.
Okay, sure.
All right, Ms. Wood, should we get rolling and get on the record, or do the two of you need to interact a little bit more?
No, Judge,
One
it'll be a
moment.
plea. We can keep moving if the court.
Great.
Yes.
All right, well, let's do that. So, Mr. Wharton, for me to consider your pleas in these two cases, you need to be put under oath, which Ms. Green is going to do in just a moment. But I need to get on the record first that you are waiving 2 important rights that you have. One of them is the right to have your attorney, Ms. Wood, actually right there next to you, so the two of you could confer privately if you had any questions. I can still make that happen. If we're in the middle of your plea and something goes strange and you want to talk to her privately, you just need to let me know, and I'll move you virtually into a private space where you can speak with Ms. Wood confidentially. But you can't just do that by leaning over and asking her a question. Do you waive your right to have Ms. Wood seated by your side for these two pleas?
Yes, sir.
The other important right you have is to be here in open court. There are a bunch of folks here. I don't know if any of them know you or you know any of them, but normally we conduct court here in 8D, but you're in booth 1 on the 4th floor of the North Tower. Do you waive your right to be here in court?
Yes, sir.
Great. With that on the record, then I'm going to ask Ms. Green to swear you in. Once you're under oath, Mr. Wharton, it's important that you answer all of her questions and mine truthfully and completely. And just as important, that if you have any questions, you let us know by raising your hand or saying, wait, stop, so that I can make sure you understand what's going on, okay?
Yes, sir.
Great. When you're ready, Ms. Green.
Judge. Good morning, Mr. Wharton. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Can you state your full name for the record?
Denell Wharton.
Mr. Wharton, are you known by any other aliases at this time?
No, ma'am.
Are you at this time taking any medication under the influence of any drugs, alcohol, or medication?
No, ma'am.
How old are you and how far have you gone in school?
I'm 38 years old. I have a GED and I have some college credits from Georgia Piedmont.
Do you understand that you are being charged with the following offenses? In indictment 21 SC 17964, you are charged with criminal trespass misdemeanor, criminal attempt to commit a felony, possession of tools to commit a felony. And then under accusation number 21 SC 179996, you are charged with theft by shoplifting. That's 2 counts. Do you understand that?
Yes, ma'am.
You can put your hand down, sir.
Okay.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you reviewed the waiver of rights forms with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment and the accusation, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with Ms. Lau's services?
Absolutely, yes.
Attorney Laus, do you waive a formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment?
So waived for purposes of this hearing.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
No, we don't.
Has your attorney advised you the minimum and maximum sentence for each charge that you're pleading to?
Yes, ma'am.
Under indictment number 21 SC 179641, the criminal attempt to commit a felony is a minimum of 1 year, maximum of 5 years. Possession of a tools to commit a felony, minimum of 1 year, maximum of 5 years. Criminal trespass misdemeanor is a maximum of 12 months. Under 21 SC 179996, theft by shoplifting, 4th conviction is a minimum of 1 year, maximum of 10 years. The second count, theft by shoplifting, also minimum of 1 year, maximum of 10 years. Do you understand that?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence that will represent a holistic resolution in both cases?
Yes, ma'am.
Under 21 SC 179641, the state's recommendation on count 1 is 5 years to serve, 2 with the balance of 3 years probated, reduced to time served, with a special condition that Mr. Wharton successfully enters and completes drug court, track 3. Count 2, possession of a tools to commit a felony, 5 years to serve 1, balance probated, run concurrent with count 1. Count 3, criminal trespass, 12 months to serve, to run concurrent with counts 1 and 2. Under 21 SC 179996, this case will sentence will run concurrent with 21 SC 179641. Under count 1 in this case, theft by shoplifting, 5 years to serve 2 with the balance of 3 years probated, reduced to the time served with a special condition that Mr. Wharton successfully enters and completes drug court track 3. And count 2, theft by shoplifting, is 5 years to serve 2 with the balance of 3 years probated, reduced to the time served with the special condition that Mr. Wharton successfully enters and completes drug court on track 3 to run concurrent with count 1. Do you understand that to be the negotiated resolution in your cases?
Yes, ma'am.
You understand that the court does not have to accept this recommendation. The court can sentence you up to the maximum of each charge and run those sentences consecutively or one after the other. You understand that?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as any other jurisdiction, including the federal courts?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of that sentence, of this sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, just like a conviction at trial would? And this is true. I'm sorry.
Go ahead.
And this is true regardless of any advice given by your attorney or anyone else. Do you understand?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction at trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have a right to a trial by jury, a right to see, hear, confront witnesses called to testify against you, and the right to testify or remain silent and not incriminate yourself?
Yes, ma'am.
You understand by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial in your case, the right to the presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of criminal attempt to commit a felony, possession of tools to commit a felony, a criminal trespass, and indictment number 21 SC 17964, and theft by shoplifting 2 counts in accusation number 21 SC 179996?
Plead guilty, ma'am.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, if this case was to go to trial, the state will be able to prove beyond a reasonable doubt under 21 SC 17964 on June 4th, 2021. Mr. Wharton was observed entering the Dillard's department store at North Point Mall. That's located at 7000 North Point Circle, Alpharetta, Georgia, Fulton County. From the parking deck into the handbag section, Mr. Wharton went to a rack where several high-value purses were hanging and were secured to the rack by security cables to prevent theft. Mr. Wharton removed a pair of wire cutters from his pocket and cut the cables from 2 handbags. As he did so, loss prevention officer Ms. D. Allen made an announcement over the intercom for security to report to the handbag section. Officer Thaxton, who had been working a security detail at the store, responded to the scene and detained Mr. Wharton, who had begun to walk quickly towards the exit. On his person, a small wire cutter was recovered, as well as 2 empty plastic bags. Mr. Wharton had cut the cables of 2 Louis Vuitton bags with a retail value of $3,180. Under case number 21 SC 179996, on January 4th, 2021, Officer Snell was notified by Chad Harris, the asset protection manager of Saks Fifth Avenue, located at 3440 Peachtree Road Northeast, Atlanta, Georgia, Fulton County, that Mr. Wharton was observed via security camera in the menswear section, taking and concealing merchandise into a Nordstrom shopping bag. Mr. Wharton then continued to walk through the men's department, proceed down the escalator to the exit doors, passing all points of sale, and left the store without rendering any form of payment for the items that he placed in the shopping bags. Officer Snell, who was working security detail at the store, was able to spot and detain Mr. Wharton. Mr. Wharton immediately dropped the shopping bag and was taken into custody without incident. 3 Burberry shirts were recovered from the shopping bag, totaling $1,1200. On December 31st, 2020, Officer Snell was notified by Asset Protection Manager Chad Harris that Mr. Wharton was observed leaving the men's department with a TJ Maxx shopping bag appearing to be filled with merchandise. A review of the store's CCTV footage revealed that Mr. Wharton had selected multiple clothing items, then carried those items to the corner of the store and narrowed his selection to 2 Moncler jackets and 2 polo shirts. Mr. Wharton removed the TJ Maxx shopping bag from his person and placed the items into the shopping bag. He then exited the men's department, the men's department, and continued past all points of sale without rendering payment for the items. Mr. Wharton was last seen walking off the property with the items. Mr. Wharton was identified on January 4th, 2020 as the same male taking the items in December 31st, 2020 by AP manager Chad Harris. While detained, Mr. Wharton admitted to taking the items and stated that he has a drug problem, which leads him to commit these types of acts. Your Honor, Mr. Wharton has a criminal history under 15 CR 2848. He has a theft by shoplifting in DeKalb County, the conviction date 8/20/2015. Case number 15-90908. That's theft by shoplifting in Cobb County with the conviction date of March 23rd, 2015. And 17 CR 21763, theft by shoplifting in DeKalb County, conviction date 9/25/2017. And Your Honor, again, just to give the full resolution, it was a 5 years to serve 2 with a balance of 3 years probated, reduced to the time served, with the special condition that Mr. Wharton successfully enters and completes drug court under track 3.
Thank you, Ms. Green. That was very thorough. I've got a couple questions for you, and then I'll hear from Ms. Wood. First, has Mr. Wharton been accepted into drug court, or there is a hope that he can go to drug court?
It is my understanding that he has been accepted, and the condition now is that he successfully completes that program. I can look in the notes really quick. Give me a moment.
Oh, okay, no, Ms. Nelson sent me this morning already that paperwork, so I can answer it for you. It's good news for Mr. Wharton, assuming he's serious about drug court. So we're good there. Second question is, do you have any concerns that we are running afoul of the theft by shoplifting statute that requires that year to be served and not probated or reduced in any way? I don't think Mr. Wharton's been in custody for a year. My guess is he's been in since June. Still a long time, but less than a year. And I know that the sentence you're asking me to pronounce is effectively 5 to serve 2, but that 2 would be reduced to time served to get Mr. Wharton into drug court, which is probably a good place for him to be. So I'm not opposed to that notion. I'm just wanting to make sure that you don't think, Ms. Green, that we're bumping up against an immovable object.
I understand, Judge. I do see that on the 4th, the subsequent conviction, that it is a mandatory 1 year. One moment.
Judge, if I may interject.
Yes, please.
So he actually has been in so he was originally arrested on these cases January 4th this year. So he sat in Fulton County Jail from January 4th, 2021 to April 21st, 2021, which was 108 days. And then he was released to the Coweta circuit to handle some business down there. And then it's my understanding he was brought back to us. And Mr. Wharton, correct me if I'm wrong on that, on June the 4th, 2021, and up until now, which would be 201 days. So he's been in right at, just on our 2 cases, 309 days total.
And I want to be clear, I don't have a problem with this disposition. I think getting Mr. Wharton the help of drug court, or giving him, let's say, the opportunity to help himself through drug court is a great plan. And as long as, Ms. Green, you're comfortable moving forward with what you described, I'm not going to stand in the way of it. In particular, given the math that Ms. Wood has just shared with us, it seems like almost an academic exercise to say, well, you need to spend 51 more days in jail before you can get into the warm embrace of our accountability court. So you and I haven't worked together before, Ms. Green, so I want to make sure you were okay with what you described.
Yes, Judge. I want to respect the negotiated resolution that Ms. Wood and Ms. Charles worked out. So I would like to keep everything in place.
Okay. Well, great. Well, thank you. So Ms. Wood, what do you want to tell me about Mr. Wharton?
Thank you, Judge. Very briefly, he's 38 years old. He has a stable address over in DeKalb County, 5416 Fair Creek Way in Lithonia. He lives there with his fiance Jamila and their children. He does have his GED. He's currently unemployed. He was most recently employed for the past 3 years at H&F Burger in Ponce City Market. He did lose that job due to the pandemic, and that is sort of what led to his relapse. Mr. Wharton may want to share with you, Judge, more information about his desire to go into drug court. He has shared with me that he struggles with cocaine and has done so for the past 15 years. I do know that he was one of the cases that was referred into drug court when he was with our pre-indictment team. And so he spent a lot of time going over everything with his pre-indictment attorney, and she's actually the one who made the initial referral. And so then when I got the case, we went back over everything and waived indictment on the second case so that we could wrap it all up together. And so we just asked that you accept the state's recommendation.
Okay. And so Mr. Wharton, do you know why you didn't go into drug court on a pre-indictment basis?
No, sir. We were just actually waiting to get all the paperwork together and to get both cases ran concurrent. So it was a process doing that.
Got it. Well, that's happened now. All right. Well, I've got a few questions for you. How how do you plan on getting to drug court? Some of it is virtual, some of it is in person. The in-person part will be far away from Lithonia. And I ask that only because I guess full disclosure, I'm one of the 2 drug court judges. So you've got a coin toss likelihood of getting stuck with me in drug court. That'll be fine. If you do work with me, that's a coincidence. It's not because you took a plea in my courtroom, but 50-50 chance you'll be with me or with Judge Krause. But regardless of which judge you're working with, you'll need to get to Hope Hall on a fairly regular basis, especially for your UAs. And we often struggle with clients who don't live near public transportation or live far away. And Lithonia is a wonderful place. Sounds like you've got a good household there with a fiance and some kids, but you're going to need to get yourself from Lithonia to Hope Hall fairly routinely. What is your game plan for that?
I have transportation measures set up. I'm well aware of the fact of where I am, and I know exactly where the drug court place is. And I've spoken to my fiance routinely. She works nights, so the daytime should be available to take me from point A to point B.
So she's got a car?
Yes, sir.
Okay, and she loves you enough, she will get you all the way to Hope Hall?
Yes, sir.
Okay, great. And you appreciate, I'm sure, that drug court is not just a way to avoid going to jail for charges. Heck, you've been in for almost a year anyway in connection with what your addiction is doing to you. But it's not a cakewalk. It's a rigorous program because it's designed to make a difference in your life. It's not just watch a few slideshows and get a certificate and we hope everything is okay. You are prepared to engage with the program?
Absolutely, sir.
And you understand that if you are the A+ student in drug court, it's still 18 months long.
Yes, sir.
Okay, great. Well, if you're aware of those things, it is designed to help folks who are working through the kinds of things you're working through. Do you have any questions for me or anything you want to add, Mr. Wharton?
I was just only one thing. I just wanted to know, like I said, I have 2 young daughters and I miss Thanksgiving. Like I said, I've been gone for most of the year. I just wanted to know if it was possible for me to be home for Christmas to be with my family, sir.
So that's a good question. Ms. Green or Ms. Wood, was this plea set up for a release to drug court, meaning they would get Mr. Wharton on the next orientation date, or how were you envisioning that Mr. Wharton was going to make that connection to drug court? Because typically, to answer your question, there would then be an order I would sign that lets the sheriff know that when folks from drug court show up to get you, sheriff's supposed to let you go and you're not coming back. You are being released to drug court. They get you over to Hope Hall, get you signed up, and then you go home. That's the normal way we do it, but it is December 21. So I'll need to reach out to drug court to see if they've got a pickup date this week. If they do, that's my preference, is that we release you to drug court folks. I just don't have that answer at my fingertips. Ms. Wood?
Judge, that's my understanding. I know, and I hadn't heard back from Mr. Abrams to confirm whether the home visit had been completed yet for Mr. Wharton's location. I know that is one of the things that they usually try to do. And I know that Ms. Primovic had gone over quite in depth with our office about how drug court, once you plead, that does not guarantee that you're going to get released. So Mr. Wharton and I did discuss that we could not guarantee when he would actually get out of custody. But it is my understanding that drug court would be securing his release when they are available to do that.
Okay. So Mr. Wharton, what I will do is put in a request to drug court that they move this quickly, because I understand your request. But I will tell you, if you get, like I said, assigned to my half of drug court, you'll hear me say this a lot. Your recovery comes first, and Christmas with your kids has got to be close to the top of the list of things that are important in your life. And I hear you and understand why you want that. And it's healthy that you want that. But you being in their life and still struggling with cocaine is less healthy for them than you being in their life a few days after Christmas and already plugged in with drug court. So I will make the request that drug court do what they can to get you to orientation if they're doing one this week. I know we've got drug court. I've got drug court tomorrow. So things are happening. I just don't know where you'll fall into that, but Ms. Wood is exactly right. They will get you out. They just need to make sure all the pieces are in place. So I don't want you to start drug court with bad taste in your mouth. If that's not till early January, it's not because we've forgotten or we're moving slowly. This is just where you are falling on the calendar. But I'll make that request and we'll see what happens. Okay.
All right. Thank you, sir. God bless you.
All right. Well, you too. Well, Mr. Wharton, I find there's a factual basis for both your pleas. Sounds like you were a fairly sophisticated shoplifter and you weren't going just for the batteries or deodorant at a CVS, but stuff that you could get a pretty penny for, assuming you were reselling, as opposed to you were going to be walking around in the Burberry shirts and all that stuff that I only admire from a distance. So I think the state could prove both these cases. I also find that your pleas are knowing and voluntary. A voluntary plea means, Mr. Wharton, that you are deciding to enter these pleas because you believe that it's in your best interest to do so. Your lawyer may have told you that, your family may have told you that, but ultimately it's your decision and it's the decision you're making freely. Is that correct?
Yes, sir.
And a knowing plea is simply one where you feel like you've understood all the things we've been talking about. I get the sense you have, but I need you to tell me, do you have any questions about any of the things Ms. Green went over with you?
I completely understand. I'd just like to thank the court and thank you personally, sir. And I appreciate you guys letting me get an opportunity to attend drug court.
All right. Well, the true thanks will be you engaging in drug court. And as you succeed, being a mentor to others, because you've got a good support network in place with a fiance and some kids, and you clearly are employable. You've worked before. You're going to meet some folks who they have none of that. Their life is the drugs and the food they get out of a dumpster. And they are going to need folks who have demonstrated, you know what, I can do some. You went to college for a while. So I'm hoping that once you get stable in drug court, you will be in a position to give back a little bit to the folks in drug court who haven't enjoyed some of the things you have enjoyed in life. So, Mr. Wharton, I'm going to, for the most part, follow the recommendation. I'm going to tell you why it's different, and you'll have a chance to say, I don't like that, and I reject what you did, Judge, and then you can withdraw your plea. I am going to sentence you pursuant to the Probation Options Management Act. And all that means is that while you're on probation and out of drug court, because hopefully there is a little bit of probation left when you're done, if you have a technical violation, something small while you're on probation, you and probation deal with that. You don't have to see me. But if it's more serious, you get new charges, that'll come back to me. So both your sentences are pursuant to POM, as we call it. What I'm going to do in the case ending in 641 is sentence you on counts 1 and 2 to 5 years to serve 2 years with the balance on probation. I'll reduce those 2 years to all the time you've served. And then, as I said, the remainder will be on probation. But count 3, that 12 months, I'm going to run that consecutive to count 1, and I'm going to probate it. So your overall sentence is actually 6 years to serve 2 years, reduced to time served with the balance on probation. So it's potentially up to 4 years probation. More on that in a minute. And it is a special condition of your probation in the case ending in 641 that you enter into and complete the drug court program. In the case ending in 996, that's your accusation with the 2 Saks Fifth Avenue shopliftings. Your sentence on both counts will be 6 years to serve 2 years. Those 2 years will be reduced to time served, and then it'll be 4 years on probation. That sentence in that case will run concurrently at the same time with your sentence in the case ending in 641. And it will be a special condition of your probation in the case ending in 996 that you enter into and complete the drug court program. I'm baking in 1 more year of probation for this very important reason. Drug court usually is an 18-month to 24-month program, but sometimes folks hit roadblocks. Sometimes someone disappears for a little while. They come back and we want to try again. We give them a second chance in drug court. I want there to be enough time on probation so that we don't run out of probation and you're still in drug court. Because if your probation expires while you're in drug court, we lose the ability to supervise you. And it has happened too often. And it's happened to folks who need drug court the most because it's taken them longer to get through. I get the sense that you're going to move through it just fine. You're going to learn more about what your triggers are and your stressors, and the folks in drug court will help you with that. And so this may be unnecessary to tack on that extra year, but I'd rather be safe than sorry. I can't add a year later. This is the only time I can do it. And so I'm not doing it to be punitive or because I think, oh my gosh, you're worse than people are saying you are. Look at your criminal history. It's shoplifting. And that is 9 times out of 10, someone who's got an addiction or there's a mental illness. So you are a great candidate for drug court. And I hope that you take advantage of that opportunity. But I think that building in that extra year will make this a smoother process for you. That said, you've got the right, Mr. Wharton, to say, no, thanks. I was willing to do 3 years probation, but not a minute more. I'd rather withdraw my plea and have these 2 cases move on towards trial or some other resolution. Do you need to speak with Ms. Wood about the change that I've made, or are you comfortable moving forward?
I'm comfortable moving forward, Your Honor.
All right, well, we will do that. The last thing I've got, Ms. Wood, we are working off a copy of both the indictment and the accusation. Do you waive any issues that would arise from that?
Yes, Judge.
Mr. Wharton, if you were here in court, you would personally sign both the indictment and the accusation indicating your guilty plea, but you are there and I am here. Do you authorize me to sign those 2 documents for you electronically?
Yes, sir.
Ms. Wood, may I sign for you?
Yes, Judge.
And Ms. Green, may I sign for you?
Yes, Judge.
Great, I will do that. And I think we're all set. Ms. Wood, anything else for Mr. Wharton?
No, Your Honor.
Ms. Green, anything else?
Nothing from the state.
All right, Mr. Wharton, I will do what I promised, which is check with drug court to see if there is a expedited way we can get you plugged in with them. If there is, they'll do it. They're good folks and they're anxious to get working with you. If there's not, hopefully no hard feelings. We'll get you plugged in as soon as we can. And I hope I win the coin toss and get you assigned to my division. But Judge Krause is wonderful and you work with her if that's where you get assigned, okay?
Okay.
Probation instructions, Your Honor.
Yes, Officer Brown. 2 questions for you. Thank you. Mr. Wharton does have these older cases. Are any of them open and active such that we need to worry that Cobb or DeKalb is going to try to grab Mr. Wharton?
No open probation, Your Honor.
Fantastic. Yeah, tell me how we do the probation reporting, because Mr. Wharton will be supervised is the wrong verb, I know, but basically he's going to be subject to drug court and not having to report routinely to probation. But how do we work this?
Well, there is an officer assigned to drug court to actually monitor the defendants.
Right, Officer Malud.
Yeah, Officer Malou, she will monitor the defendant in the program as far as completing reporting, and anything that's been reported will be documented in our system so we can have a track on it. And
Okay.
if we need to assist on any violations, we will assist if needed.
Sure, but should Mr. Wharton report to the DeKalb probation office soon after release? If he needs to, he should.
If he's residing in DeKalb, yes.
Okay.
I just need that address and contact number for our records, and I will give a DeKalb reporting instructions.
Fantastic. So, Mr. Wharton, if you could please share with Officer Brown your home address and a good phone number, whether it's for you or for your fiance, so probation can reach out if there's an emergency.
Okay. Are you ready, ma'am?
Yes.
Okay, my address is 5614 Fair Creek Way, Lithonia, Georgia. I'm going to say it's 30088. And the phone number is for my fiance. Her name is Jamila Simmons. And the phone number is 347-446-1562.
Okay, we're going to report to the DeKalb probation office located at 981 East Fairway Drive, Southwest Suite A in Conyers, Georgia. The number for the record is 770-388-5929. And then report at 9:00 a.m. Is their reporting time. And you're going to report on January 5th, 2022, of course, at 9 a.m. And failure to report on that date and time will result in a probation warrant. Nothing further.
So you say January 5th, and that's in, I was aware of a DeKalb County office on I believe Miller Street. Is that no longer available?
No, they relocated.
So it's in Conyers?
Yes.
And that'll pull up on the internet, because I don't have any paperwork that'll pull up.
Just you can call. You can actually call the Fulton County office, and they'll give you the address if you need it. But you can Google the DeKalb probation office, and it will come up.
And Mr. Wharton, Ms. Wood has all this information as well. So if you know how to reach Ms. Wood, we're not trying to trip you up here by having you memorize this long, complicated address. She's got all the info, and you'll just want to make sure you get to their spot on that date. And then generally, you don't need to worry about probation as long as you're doing drug court. As Officer Brown mentioned, there is a probation officer assigned to drug court, and that's the way probation will make sure Mr. Wharton is doing what he needs to do in drug court. So it's just that first day that you sign up.
Basically, that's just an initial report when I'm released.
Yes, sir.
Okay.
All right, Ms. Wood, does Mr. Wharton know how to reach you so that if he needs to reaffirm his understanding of the address and the date, you've got all that?
Mr. Wharton, do you have our office numbers?
Yes, ma'am.
Okay, so if you need me before the 5th, it's probably best if you call the main office number and ask for the duty attorney and get that information from them.
Yes, ma'am.
I might not be in the office.
All right. That's it. Thank you, Mr. Wharton. You are free to go. Good luck. And maybe I'll see you in my courtroom for drug court.
Okay, thank you, sir.
You bet. I have been asked by the sheriff's folks to do Mr. Walker next. He is in medical. He is position 3 on the big calendar, and then he has an add-on because he picked up a new case. Who is handling Mr. Walker's case on the defense side?
I am, Your Honor. Good morning.
Good morning, Mr. Webb. Let me remove the spotlight from Mr. Wharton. There we go. Mr. Wharton, you're welcome to leave the booth. You can stay there if you want, but you're good. All right, medical, you've unmuted. Fantastic. And let's get spotlight there. All right. There is Mr. Walker. Mr. Webb, you represent Mr. Walker, and he is on for plea and arraignment in his 2 cases. Mr. Webb,
Yes,
is Mr. Walker waiving arraignment? What are we doing?
Yes, he is. We waive formal arraignment and enter a plea of not guilty. I've actually already filed a waiver of arraignment with the court. And so that's where we are, Your Honor.
Okay. So, Mr. Walker, hold on. I'll hear from you in just a sec. I'm Judge McBurney. I don't know that we've met. You've got 2 cases in my division. One of them is charges you with theft by receiving stolen property, and the other one has an aggravated assault and kidnapping allegation and some gun stuff. What Mr. Webb has done is let me know right now you're pleading not guilty. Mr. Webb is going to get the discovery, the evidence that the state has in your 2 cases. He will look at that, and then he will get with you so you can look at it, and you and he will decide, are there any motions you want to file, and what are you going to do next with your case? That's when I will see you next, is if there are any motions that need to be argued. And then we'll see whether the case is something that can be pled out or if it's something that you want to take to trial, and we'll get you that trial. Does that make sense, Mr. Walker?
I never was offered a plea, no type of plea on arrangement, nothing of that nature, sir. But I haven't spoken with no one. I haven't spoken with no lawyer, nothing. No one. This is my first time really speaking with someone.
Yep. I hear you. That's what this is. This is your first appearance. This is your first appearance with me. I haven't talked to you before either. And the only thing Mr. Webb is saying is, you know what, Judge? Right now, we're saying not guilty. And then he's going to get with you. Mr. Webb will come see you. You guys will talk. He will bring you the evidence that the state has given him. And then you and Mr. Webb will start talking about, hey, is this a case that we want to work out, or is it something that we want to take to trial? So no big decisions have been made in your case. That would not be appropriate because, like you said, you and Mr. Webb haven't had a chance to get together yet. He is simply saying, I'm Mr. Walker's lawyer. And for now, Mr. Walker says not guilty, and he's demanding discovery. So we'll make that happen. And then only after you and Mr. Webb have had a chance to talk, probably several times, will Mr. Webb then let me know what's happening next in your case, okay?
Yes, sir. All right. Can I ask Mr. Webb when he's come speak with me?
Sure. Mr. Webb, when are you hoping to swing by the jail to meet with Mr. Walker?
Well, I will come as soon as I can, Your Honor. The jail was on the other day, and I understand he's at medical now.
Okay.
And I'm going to be going into surgery myself on December 28th. So I will do my best to get there between now and then, but I can't guarantee that. I could send somebody from my office to talk to him.
Yeah. So,
I'm sorry, Your Honor. It's a third.
Okay. He has a third case?
I think so. I think it's also assigned to you, unless one of these was a re-indictment. It's 21 SC. I'll give you the number, Your Honor.
Oh yeah, it's on the calendar. 178.
178-544. Yes, sir.
Yeah.
I think the state had filed a notice to introduce hearsay testimony. They're going to withdraw it.
Okay, I see. Yeah. Another aggravated assault. All right. So, Mr. Walker, you got 3 cases. All right. Mr. Webb will come see you when he can. And like he mentioned, he's going to have a little surgery to become an even more powerful lawyer after that. And so if he's out of commission for a little bit, he will have a colleague from his office to come see you. Okay.
Yes, sir.
All right. Thank you, Mr. Webb. Thank you, Mr. Walker.
You're welcome, Your Honor.
You're free to go, Mr. Walker.
May I be excused, Your Honor? I think that's my only cases.
If those are your only cases, Mr. Webb, then I wish you best of luck on your surgery. Please keep us posted as to how it went, that you emerged okay, that you've got a new bionic knee and all that stuff.
I will, Your Honor. And a Merry Christmas and Happy New Year to you.
All right. You too. Take care.
All right. Thanks. Bye.
Bye. All right. Let's do one of our in-person matters. I saw that Ms. Davis is here. Hello, Ms. Davis.
Good morning, Judge.
Good morning. How are you, sir?
Very well.
So remind me, this just says status calendar. Of course, we're dealing with a case that is now 5+ years old. You've been working with several different prosecutors. You worked with Ms. Hall. She is sadly no longer in this division. We've got Ms. Charles, who's fantastic. Ms. Charles is not here today. We have a guest prosecutor. I got to find out what division she's in so we can try to convince her to come here, Ms. Green. But remind me what we're doing with Ms. Davis today.
Judge, good morning. Good to
Good
see
morning.
you. Here's my understanding. We have been here. You had us. We were arraigned and waived arraignment on September the 8th.
Mm-hmm.
And this is on 16 SC 147083.
Yep, I'm calling it up right now. Okay.
You had us back on October 26th for a status hearing. And my notes were that Ms. Hall was going to consult with Ms. Collier about a potential null pros and notify everybody. I did not ever hear from Ms. Hall. I did hear from an assistant district attorney late last week, whose name I didn't write down because I was in my car.
Okay, that's probably Ms. Charles.
That's exactly who that was.
Okay, did she have a British accent?
I remember it was Elch. It was Charles. I do
Okay,
remember that
yeah.
name. So here's what I told her. My understanding had been from Ms. Collier that if Carly did not have any new incidents, and if we submitted, and we in fact submitted proof to Ms. Collier that she was having random tests over at St. Jude, and everything was going well, that they were leaning toward null processing the case.
Mhm.
And I gave that information to Ms. Charles, and that's what we understand at this point.
Okay.
And the complication that sort of drug this thing out was that while she got going with St. Jude as soon as she could after we got her out of the last probation jail time down in Fayette,
Mhm.
probation was slow to get it established, and she went. Turn that thing down. She went down multiple Tuesday mornings to intake to probation in Fulton. They didn't have her paperwork. Now I've tracked that back. It was a personnel problem down in Fayette that led to that problem.
Ms. Davis lives in Fulton County, the
She
current
does.
residence would, so Fulton is the right place for her to be
That's
plugging
right.
in.
That's right. And so what Judge Sams was going to have her do is continue St. Jude, go to the DRC, which again couldn't get started till probation got started.
Mm.
So all that's in place now. In the meanwhile, she's continued to work over at Michael's, but she let me know today that she is about to start a new job working at an animal hospital over in DeKalb County on Claremont. I think it's Vet Clinics of America affiliate that's just off of Briarcliff.
Mhm.
So everything's going really well. And while we thoroughly enjoy coming to see you regularly, I
Got other things you could be doing.
I got other things I could be doing, and I guess I need to find out where the state wants to go, because I did opt into Discovery back in September. Haven't heard anything back. It looks to me like that we're on the precipice of null crossing this thing, but just can't find anybody to sign it.
Sure. So two things. First, congrats on the new job. Have you ever done veterinary work before?
Sir, a friend of mine works there that I met at St. Jude's, and she got me the job. So I'm very excited about it.
Good. It smells different at a vet than it does at Michael's.
A little bit.
Yeah. Okay. Well, good for you. And is it full-time, part-time?
It's going to be full time.
Excellent.
I'm making almost double of what I was making at Michael's.
Holy smokes.
Yeah.
Okay.
I'm very excited.
And are you going to be the type of person who helps like keep the dog still while the vet is taking the temperature, or you're at the front desk, or what will you be doing?
I applied for the kennel tech position, and they had already filled that. So I'm actually doing like the front desk customer experience, and they're going to train me to do the kennel tech.
Fantastic. On the job training. Good. Number two, let me ask Ms. Green, and Ms. Green, you are in no way on the spot on this one. This is a case through no fault of yours, has bounced from Ms. Collier, who appropriately had it when it was a drug court case, and it really was before Ms. Collier even. It was the drug court prosecutor before her, Ms. Hackworth. That's not Ms. Hackworth. Miss Sellers. Then it was Ms. Collier. Ms. Hall was going to try to sort it out, and now Ms. Charles. What do you have, if anything, in your notes about this case?
So I do have that Ms. Charles did speak to Ms. Collier, and it's simply a matter of Ms. Collier confirming and getting copy of the drug tests to make sure that everything is good, and then we will give the go-ahead to close out the case as soon as she receives that.
Okay, so why don't we do this? Rather than make either of you come back here, I'm going to put this on another status, but it will be a non-reporting status. It will be a reminder for Ms. Nelson and for me to bug Ms. Charles, who's the prosecutor in here, who will actually be getting with Ms. Collier. But I think it's going to, I don't know if you've already sent those things, and so your frustration is, gosh, I sent them to person X and I need to go to Y.
To go, Judge.
But we can connect those dots. Those dots are connectable. So what I'm going to do is have this reset for 30 days. Do not come to court in 30 days, because my hope is, well, before then, I'll see the null pros proposed order from either Ms. Charles or from Mrs. Collier, as this is what they want to have happen. If for some reason they feel like there's a missing piece, we can have a phone conversation about it, but you don't need to come down here, assuming everything goes well. Now, if what Mrs. Collier or Ms. Charles learns between now and then is that there was some adverse development, then we may need to meet again. I hope that's not.
Judge, back before probation had the case, we were having to hand deliver or send what we could get from St. Jude to Ms. Collier. Probation's established now. There is testing going on, regular testing in St. Jude. There's also random testing going on through the probation folks. So I think now the district attorney is able to get these things without me having to be the errand boy.
Good. Okay. Well, I'm going to build this 30-day window because over the next week plus, we're not going to get anything done. So 30 days out, this will be back on a calendar. Please don't come to court unless you get a call from Ms. Nelson saying, oh, actually, you do need to come to court. So if you simply get notice of the calendar, I am excusing you now from coming to court. And hopefully well before then, I's will be dotted and T's crossed on the DA side, and they'll follow through with the dismissal if that's what they decide
I
to
think
do.
it's a safe thing to do, Judge. If I get a notice from you, I'll talk to your office and just confirm that.
Great. Okay. But you can remind them that I said you shouldn't come to court. All right. Good seeing you, Ms. Davis.
Thank you.
Thanks both.
Judge, good to see you.
All right. Let's see what we got here. Lieutenant Dooley, is there a particular order in which you want to handle the rest of them, or should I just open up a booth and start talking with someone?
No order in whatsoever. I'm sorry, I've been running back and forth to courtroom 3. Are there any inmates that you need me to call the floors for again?
I don't know. We haven't taken attendance. When we started, there wasn't, you were busy. And so I just turned on one of the booths and said, who are you? And it ended up being a police. So we took the plea. So I'm just going to go to 1 North now and we'll handle 1 North.
Okay, that works.
All right. Thanks. It's thinking hard. Come on. That's a bad development. Let's see. All right, we're gonna have to try something other than 1 North because that didn't work. Let's see what else we can find.
Judge, did you try the other booth? You're the only one up today.
Yeah, I did. I'm trying a different approach. I'll come back to it, but I'm getting an unhappy face from the technology here. So
Okay.
we'll sit tight, but we got a couple others. So I'm gonna try another one.
Okay.
Hey, 7 South, who do we have in 7 South?
Dr. Hurt.
Mr. Hurd, how are you?
Okay, Judge. How about yourself?
I'm all right. Mr. Harvey, you good to go?
Yes, I am, Judge. Can you hear me?
And Ms. Beza, I think you've been on the call as well. There you are.
Good morning.
Good morning. So we are on for a motion to reconsider bond that Mr. Harvey filed. Can I have an update? I guess this can be part of your presentation, Mr. Harvey, but I know that this case was continued. It was something of a joint continuance because of a need to, I think, get information from MARTA to experts that Mr. Harvey was seeking to retain to figure out about a fence or a gate that gave way, resulting in both Mr. Hurd and the deceased falling. So let me know what's going on with that as part of your presentation, Mr. Harvey.
Sure, Judge. Let me go directly to that. I received last night 4 pages of documents from the state with regard to a Open Records Act request from MARTA. 4 pages. Those pages were only related to after the event occurred and the reconstruction of the gate. I received nothing with regard to anything before the reconstruction or at the time of the event or any anything related to any investigation by MARTA or MARTA's insurers with regard to the incident itself. And I do know that MARTA investigated the incident. The MARTA's insurers investigated the incident. And I believe, and will represent to the court and the state, that MARTA's insurers told MARTA that they have potential liability both from Mr. Hurd and the alleged victim in this case. There's a wealth of material out there that has not been provided by either MARTA or the state, number one. Number two, I've had a preliminary examination of the rail by a investigator, but I am awaiting additional information from both MARTA and MARTA's insurer. That's where we stand at this particular time, but I do have a preliminary investigation by an expert of my own. Number two, I know that there is potential civil litigation out there on behalf of the alleged victim's family and Mr. Hurd against MARTA, and that the state, for some unknown reason, has both talked to and provided information to the plaintiff's attorneys in this particular case. I don't quite understand how that happens, but that has indeed happened. But there is still a potential lawsuit on behalf of Mr. Hurd against MARTA out there. Number three, there is no video of this event. Let me just say that again. There is no video of the actual event here. And after the event here, Mr. Hurd was also taken to the hospital and injured in this particular fall. Number four, as of today, Mr. Hurd has been incarcerated 673 days awaiting trial. And that trial doesn't seem to be on the immediate horizon, as well as we discussed at the last hearing. I have been in contact with the state, and we are in the process of talking about the state. In fact, the state provided an offer to me last night at approximately 5 o'clock. So we are in negotiations about the case. I can't tell you that it is going to be resolved. I'm not sure that it will be. I need to discuss that with Mr. Hurd. But in the meantime, I believe that after 673 days of incarceration, that he is entitled to a reasonable bond pending resolution of this matter. I'll also point out that Mr. Hurd was originally charged with 2 offenses. Those 2 offenses are included in the indictment here. The event here occurred on February 15th of 2020. He was not indicted until November of 2020. So he's entitled to bond on malice murder charges, possession of cocaine charges. He was also indicted for felony murder and aggravated assault. There, the only charges resulting from the exact same occurrence that were added in the indictment, but he is certainly, I believe, entitled to bond on all these charges. With regard to Mr. Hurd, he's 35 years old. He's lived here in the Atlanta, Georgia area his entire life. He's got 2 minor children. His mother is a 20-year employee of the Department of Revenue. And his stepfather lived together at 495 Pecan Wood Circle. That's where he would live in Fairburn, Georgia. He would live there with his mother. There is $250,000 of equity in that property that his mother and stepfather would put up to assure his presence at trial. He graduated from Georgia Youth Academy. He's got a forklift certification from Atlanta Area Tech. He worked at a location at a place called Material in Motion. He also worked at that location, which is 1000 Logistics Center Drive in Fairburn, Georgia. He worked there for approximately 4 years. He has glowing reviews from that company, and I have his annual performance review forms. I've got a letter from his boss, his supervisor named Ronnie, R-O-N-N-Y, Sorrow, who says that he was working there for approximately 4 years prior to this event, and that he was an exemplary employee. He has also got an employment offer from Vector Force Development. That's Vector Force Traffic Control. This is dated December 16th, 2021. His name is Jeff Sexton. His phone number is 470-217-6747. And he's offered Mr. Hurd a position as a traffic control flagger for $15 an hour, should he be released and allowed to work. I don't believe, I think I was provided with a GCIC, but I don't believe Mr. Hurd has any prior convictions. He's worked, he's had a job. I believe there's serious problems with this particular case. He's been incarcerated for 673 days. He meets each and every one of the Ayala factors, and I would ask the court to set a reasonable bond.
Mr. Harvey, do you know, and Ms. Beza is going to answer this question anyway, but maybe the two of you have talked about it. Do you know why it has been so difficult to get information from MARTA / why an open records request as opposed to a subpoena or someone trying to get from me an order saying you have to divulge this, that someone's been charged with murder, someone died, and it involves people leaning up against a MARTA fence or gate. I'm confused.
Okay, and I can tell you exactly, I thought it was easier to get the information through a Open Records Act because MARTA's a public institution. It took me almost 60 to 90 days to get the right person. They kept telling me a person, they kept telling me another person, they kept telling me another person, and we finally got to the right person. MARTA is extremely, I don't know how to put it.
Put it charitably.
Yeah. I don't know how to put it without swearing. And you know me, that would be my first fallback.
Yeah.
But so we finally got to the right person. I'll tell you why we didn't subpoena it, because we didn't have a hearing to subpoena it to.
I'm happy to set one, but
okay. Well, look, I have complained for years that the state has issued subpoenas to non-existent hearings and received documents to non-existent hearings, and I'm not going to do the same thing. I'm sorry, I'm just not going to do the same thing. I got a response from MARTA prior to the last hearing, but there are also things that we requested that they did not provide. And so we were still in the process of getting items from MARTA, and which they promised to provide. So I didn't need to subpoena them, and I didn't need to subpoena them to a particular hearing. I also thought, number two, that when the state made a request, MARTA is going to respond to the state with a full boat. They respond to me by saying, "Oh man, this is some damn defense lawyer. We're gonna give them the runaround." So I wanted to see the combination of what they responded to. I don't know whether that successfully or appropriately answers your question, but I want to let you know that I have been diligently pursuing that. The state has provided me yesterday with 4 sheets of paper talking about what MARTA did after the event and how they repaired that that particular railing. I don't know in a criminal case whether subsequent repairs may or may not be admissible, and that's another issue that may be before the court if we go forward with a trial of this case. So that's where we are.
got it. Ms. Beza, good morning. Thank you for being here. Tell me, please, your thoughts about where we are with the case, why it's taken so long to get info from MARTA, and then obviously the main topic, bond for Mr. Hurd.
Yes, Your Honor. And I did, first and foremost, I did send Mr. Harvey the recommendation and the MARTA records recently. I was out the office these last couple of weeks due to a death in the family. So I'm just now recently starting to catch up. Regarding MARTA, MARTA, the state has subpoenaed the records and also did an open records request. We kind of approached it from both angles. MARTA, as I emailed to Mr. Harvey, I actually forwarded him the exact response from MARTA saying that there were no records of construction regarding the railing going on at the time of the incident. The only records regarding the railing is what I gave to him, which was record of MARTA fixing the railing. I actually forwarded him the exact response from MARTA, from a LaToya Hunter, who works for MARTA. Regarding MARTA, they do give you the runaround. We've subpoenaed the records and did an open records request for months. Finally got some records, and that is what was provided. In regards,
so what about Mr. Harvey's observation that he believes, he's got a good faith basis to believe, and this would make sense, MARTA conducted an investigation. There's someone dead on their tracks who fell through a fence or a gate. So they didn't simply just do 4 pages of work on that. Insurers were involved, et cetera. It seems like there is a trove of information out there to which you're entitled. Certainly, Mr. Harvey is entitled and would be useful as you are thinking about a way to move forward in the case, and would be useful for Mr. Harvey as well.
Working with MARTA is kind of like pulling teeth. I mean, if they stated that they provided what they had, I can have my investigator follow up again. And that's where we stand with that. I mean, from the records that they gave and from my evaluation of the case and speaking with my superiors, we did offer a recommendation. We know the kind of the trajectory of, the state knows the trajectory of this case, in which I discussed with Mr. Harvey. We will follow up again regarding to see if there's anything else. But I mean, I forwarded him really their exact response that they provided to the state.
Can I interrupt there? And I'm sorry, Ms. Beza, I don't mean to cut you off at all, but I believe the state's request was for any information regarding construction or work on that particular railing, not for an investigation or any documents related to the construction, the first construction of that gate, or the investigation related to the incident at that MARTA station. That was not what the state requested, and that was not what the state received. We made a request for all those documents, including the investigation. And their response, and this is my good faith basis, included the fact that they turned it over to their insurance company. Their insurance company provided a report. We have subsequently been, been in contact with the insurance company to try to get the results of their investigation as well. But I am telling the court, and I am telling the state, that MARTA did an investigation through its insurance company. Its insurance company thoroughly investigated this and made recommendations to MARTA, including the fact that MARTA had liability both to Mr. Hurd and to the alleged victim. And I'm trying to get the underlying documents from that investigation. So you're correct, Judge. When you say there's a wealth of documents out there, there are, and I believe 100% that they are exculpatory. And, and I know that the victim's family, the young lady who died, their family is contemplating and investigating a lawsuit against MARTA, not just Mr. Hurd. They're determining whether or not they're going to sue Mr. Hurd, but whether or not they're going to pursue a lawsuit against MARTA on behalf of her and Mr. Hurd. So the whole tables have turned, Judge, in this particular investigation. Ms. Beza is absolutely right. She sent me a recommendation last night. We have been talking about this case. I know that she had some problems with her family, and I understand that. All I'm saying is at this particular point, given the forward projection of this case and the 673 days, this young man who doesn't have a criminal history, who's got family and ties in the community, has got a job, has got a piece of property with equity of $250,000 that his mom is willing to put up, should be released on bond pending any further disposition of the case.
Okay.
Your Honor, it's the state's position that the tables really have not turned. This whole time, the state has not given a recommendation in this case because we were looking into the case and specifically looking into this railing and why this railing broke. Because at the end of the day, the railing fell with the victim and with Mr. Hurd. That's a fact. That is what happened. Therefore, that's why we were focused on the construction records regarding this railing. It's a metal railing and it broke, which is the reason why we finally have a recommendation. I've been out of the office, so I had an opportunity yesterday to meet with my superiors, but that is the only reason, a portion of the reason why we made the recommendation of the involuntary manslaughter in this case with a certain amount of years, because that is what's fair. Our position is that Mr. Hurd pushed the victim. They both fell through the rail. That's been our position from the beginning. But the question for us, for the state, is not insurance. It's not any of that. It was the rail. And that is why we're prepared either to be a resolution in the involuntary manslaughter or to take the case to trial.
Okay, I got it. And we don't need to go around on that anymore. And I should have said this at the outset, Ms. Beza. I'm glad you're back. I'm sorry for your family's loss. I know you were out of pocket, and you are plugging back in. So none of anything I've said has been meant to say, why wasn't more done in the last 2 weeks on this? I was curious as to what your experience had been trying to get information from MARTA. And you used the phrase pulling teeth, and I get that.
And the state got the information that we needed in order to make a recommendation or to prepare this case for trial.
Okay, well.
In addition, I will definitely, if you email me the insurance company name, we can subpoena whatever Mr. Harvey would like as well.
Well, Mr. Harvey's pursuing that. And so I have a couple things that I want to do here. First, I don't know, to make sure I'm asking Ms. James is on the call as the victim advocate. And I want to make sure if there's anyone from Ms. Jackson's family, that's the deceased in this case, if there's anyone from Ms. Jackson's family who wants to be heard, or if Ms. Beza, you're in a position to address that.
Yes, I mean, we spoke with the family, the daughter of the victim yesterday and the mother of the victim as well. They're against bond. They do not want to make a formal impact statement. They fully understand the state's position and why we offered the involuntary manslaughter on this case. We spoke in depth about it. They are on board. The allegations or the facts are the facts of the case. We cannot make them up. And therefore, they don't want to make a formal statement, but they do want accountability for the death of their loved one.
Understood.
And I can go into, oh, sorry, go ahead, Your Honor.
No, what were you going to say?
In Mr. Harvey's recitations, he was stating that actually in his motion as well, he was stating that the defendant has been in for a certain amount of days and we only had 90 days to indict, and we indicted it in, I want to say November. Your Honor, the time, we actually had until this year to indict given the tolling time and given the pandemic. And I can go into those dates as well. In addition, Your Honor, this case has gone through multiple defense attorneys, Eric Cho, Jacoby Hudson, and now Mr. Harvey. And therefore, it's not the state is not delaying the trajectory of this case. In fact, the state has been working hard regarding the either a resolution or preparing this case for trial. There hasn't been a significant change in circumstance in this case for Your Honor to change the bond status. It's the state's position that the ILF factors, especially the defendant, would you like me to get into them at this time, Your Honor? I didn't.
What is your information about whether Mr. Hurd has a criminal history?
The defendant does not have any misdemeanor or felony convictions. He did have a burglary arrest regarding the same victim. That case was.
Oh, I remember this because we did the 404B. This was taking the money under the pillow.
100%. And there are some unreported abuse as well. It's also the state's position that he poses a significant threat to the community. Your Honor, this incident happened at a Lakewood, a public MARTA station where there were other patrons around. The incident was not just the final state's position, it's the final push by the elevator where the gate broke. It actually started on the train in their surveillance video with a verbal argument over what was on her phone. Then he drug her up the stairs, which is on surveillance video, to the point where her bra was showing. He pushed her into a overpass or a gate on surveillance video prior to walking down the corridor. This happened at a time where there were other patrons at this MARTA station. So he is a danger to the community as well. And he's a danger in intimidating the witnesses, mainly my 404B witnesses in this case, who one has actually witnessed an incident of abuse between him and her, and the other, they know about it. So, Your Honor, it's the state's position that there has been no significant change in circumstances and that no bond should remain on this case.
And Judge, we vigorously dispute the fact that there was any kind of inappropriate conduct prior to this particular event, or that there was any pushing. This is completely speculation. And I can tell you that the state's version of what is shown on those videos is absolutely not what it shows. That's their spin on it. And that's fine. They can spin it however they want. But that doesn't make Mr. Hurd, who's got absolutely no prior record, has got a job, has got a place to live, and has been a productive member of this community for years and years and years. That does not make him a danger to the community at large. And I would vigorously oppose that. In fact, the latest opinion, and I know you keep up with the law on bond, is Coleman versus the state at 2021 Westlaw 5316383, in which the court says when fixing bail in Georgia, a trial judge's foremost consideration, in italics, is the probability that the accused, if freed, will appear at trial, and to a lesser extent, the accused's ability to pay, the seriousness of the offense, and the accused's character and reputation. There is absolutely no showing that Mr. Hurd won't appear, especially if the court fashions conditions and requires surety that he won't appear. And that's the foremost consideration for the court. And I've heard no particular facts that he presents a danger to the community, or of intimidating witnesses, or of failing to appear. The fact that there are witnesses out there is a fact in every single case.
Now, may I briefly respond? Because most of this incident, minus the final, what's the state's position, push, right? Because there's construction blocking that camera. Most of this incident is on surveillance video. So when I was mentioning that the defendant initially pushed the victim by the stairs and dragged her up the stairs, that video is clear as day. So for Mr. Harvey to say that I'm making up these facts or making up these allegations, I just wanted to perfect the record on that.
Okay, well, I've watched the videos. That was something that I asked to be able to do when we had a bond hearing when Mr. Hudson was representing Mr. Hurd. So I'm familiar with the videos. I'm familiar with both of you as advocates. And of course, one of you says you can't tell anything from the videos, or it says the opposite of what the other person says. I don't need to make a finding right now as to what the videos show, but I have watched them as well, and they were one of the reasons that I was not real comfortable setting a bond for Mr. Hurd back then. But that was back then, and it sounds like the case has progressed some in fits and starts. There was one continuance granted at Mr. Harvey's request. There have been reasons why things have taken a little while. I think it is meaningful that the state has now made an offer to something less than the most serious counts as the case is currently charged. And I do think that it's appropriate to set a bond at this point. I don't know if Mr. Hurd can make it, but that would just be a reason to revisit it in the future if it ends up having been a bond that was a little too restrictive. But I'm certainly going to err on the side of caution here and make sure that it is, in my opinion, sufficiently restrictive. And if I overshot, I am confident that Mr. Harvey will get us back together so that I can hear about how that was not something that was effectively a meaningful bond. It was the same as no bond. I also want to offer up setting down a discovery hearing, not so that Ms. Beza comes in here to explain why she doesn't have X or Y or Z, because I don't think that's where we are. But if we had a discovery hearing to which MARTA personnel could be subpoenaed by either side, or insurance personnel could be subpoenaed by either side, that might help dislodge things. But I simply offer that up. If Mr. Harvey, you don't think it's necessary because you're making progress, then we don't need to do that. But it's important that both sides get the information to which they are entitled. And sometimes setting down a hearing to which folks who otherwise might ignore a request from either of you, they pay a whole lot more attention if they got a formal, non-rejectable invite to come to court. So if that's something that you think would be helpful, let Ms. Nelson know. We'll set it down far enough out that insurance company, MARTA, et cetera, would have a chance to think again about the requests and maybe more expeditiously provide both sides with the information that they've been seeking. And I heard you, Ms. Beza, that your request was a little different than Mr. Harvey's. Yours was, we'll call it forward-looking, what's been done to address the railing. And Mr. Harvey's, I think quite understandably, was, well, what was done as a result of the incident? What did you conclude, et cetera? And I would think both sides would want all of that. So seize the opportunity if you want it. In the meantime, I am going to set a bond. The bond for count 1 is going to be at $80,000. That'll be through the sheriff's 10% program, so that money can be returned to whoever is able to put that up when this case is resolved. Counts 2 through 4 will be secured through this house on Pecan Wood Circle in Fairburn. So Mr. Harvey's team would need to get all the paperwork necessary to the sheriff's office so that they could confirm that that equity exists in that house. It would be a condition of the bond that Mr. Hurd would be wearing an ankle monitor that he pays for. He will need to reside at that address at Pecan Wood Circle. He can have no contact, direct or indirect, with any member of Ms. Jackson's family or any of the witnesses whose names were included in the state's 404B notice. Mr. Hurd will be subject to random drug screens, and through the bond on count 1, pretrial supervision at level 2. And he will be subject to an 8 p.m. to 6 a.m. curfew. He is at home, Pecan Wood Circle, between 8 p.m. and 6 a.m. unless he can certify that his job requires him to be away from that address for some number of those hours, and then we can adjust the curfew. But otherwise, from 6 a.m. to 8 p.m., he can be out and about, working, etc. But from 8 p.m. on through 6 a.m., he is at Pecan Wood Circle. Ms. Beza, were there any other conditions that you would want in place to address the concerns that you have shared with me?
Actually, no, Your Honor. My main concern was their witnesses.
Okay. Well, I think I've addressed that. If it needs to be more clear, I'll do that. Mr. Hurd, you need to understand that direct contact would be you reach out to any of these people. Indirect contact would be someone on your behalf reaches out to any of these people, whether it's to say, I'm so sorry about the loss of Ms. Jackson, or the opposite end of the spectrum, you better not come to court and testify or else. If anything like that happens, your bond disappears and you will not see a bond from me again. Mr. Harvey, any questions about that bond?
No, 80,000, 10% count 1, counts 2 through 4 secured with the Pecan property. No contact with the family, no contact with any of the witnesses, pretrial, random drug screens, pretrial services level 2, curfew 8 p.m. to 6 a.m., ankle monitor at Mr. Hurd's expense, correct?
Correct.
Now, who prepares that order?
I do.
Okay, good deal.
Now,
I'm counting on you preparing it correctly.
I have one question, Your Honor, and maybe Mr. Harvey can answer it. How much
Yes,
is
ma'am.
the Pecan property? Is that like a $250,000 I forgot what you said earlier.
Yes, it's 495 Pecan Wood Circle, Fairburn, Georgia, 30213. The home value as of December 8th of 2021 is $345,449. There is a loan balance of $61,266.69. The equity is $284,182.
So a couple things. I will probably, the more I think about it, need to set a dollar amount for the remaining counts. and it will probably be at about half the equity that's in the house, because there's this general rule of thumb of wanting to have double equity for the bond amount. So Ms. Beza, the dollar amount TBD for counts 2 through 4 added up, I'll break it out across the 3 counts, will be about 120,000, because that's a little less than half of the equity in there. That's what the bond order will say, but I am not responsible for, Mr. Harvey will be responsible for putting together the paperwork package that will satisfy the sheriff that that equity exists. It's hearsay right now, but there are documents that will make those numbers a little firmer. And so I don't put that part together. I will put together the bond order that indicates everything that we've discussed. But there'll need to be something presented to the sheriff's office so that they're comfortable that that equity is out there. And through work that I would do, we'd be able to attach that equity and say, now the house is the property of the state, because Mr. Hurd violated his bond and he has a lot of explaining to do to his mother, because it is now Fulton County's house and not the Hurd family's house.
That's correct,
So
Judge.
is it
I
a total?
Understood.
It's totaling 200,000, 80,000 for count 1, and then 2 through 4 is 120, but really it's the house.
Yeah,
Correct.
80,000 at 10%, the 10%
Correct.
program.
Correct.
Okay,
Okay.
I understand.
Mr.
All right.
Hurd, you heard all of that. You understand all of that, correct?
Yes, sir. Yes, sir. Yes,
All
sir.
right, great. Good deal. Thank you, Judge. May I be excused?
So yes, but again,
Yes, but
if you need there to be a discovery hearing so that we can invite our friends from MARTA or the insurance company, please let Ms. Nelson know. What is not going to be persuasive to me is if we are together again in 60 or 90 days and you want the bond modified because Mr. Hurd can't make it and you still don't have the kinds of things you're trying to get, because
Understood.
I'm offering you an opportunity to expedite that.
Yes, sir. I understand.
Great. All right. Thank you, everyone.
All right.
May I
Thank
be
you.
excused as well?
Yes, ma'am.
Bye-bye.
Thank you.
All right, Mr. Hurd, you're free to go out of the booth.
Merry Christmas.
All right. Let's find another booth. 6 South. Did you get all that? Okay. Hey, 6 South. Whoa, that was loud. Who do we have in there?
My name is Brandon Way.
Brandon Way. Good morning, Mr. Way. You're position 1 on our calendar. I believe this is Mr. Abate's case from the state. And Ms. Wood, you're handling it for now?
John, I am Ed Adams.
Hey, Mr. Adams. Thank you for joining us.
Thank you.
So, Mr. Adams, Mr. Way's case is on for plea and arraignment. Is Mr. Way going to waive arraignment, or does he want to be formally arraigned?
We'll waive arraignment, John. I've discussed it with him and we will waive it.
All right. So, Mr. Way, I will enter an order soon, today or tomorrow. That is a scheduling order. It will give the state a deadline to get to Mr. Adams the discovery in your case. And then Mr. Adams will be in a position to sit down with you to go over the state's case, what they've got that's good or bad or messy. And then Mr. Adams will have a deadline to file any motions. I don't know anything about your case, but I'm making this up. Maybe you gave a statement to the police and Mr. Adams thinks it should be suppressed because they didn't Mirandize you or whatnot. When you and he can look at that discovery and talk about it, he'll be in a better position to know what motions he's going to file on your behalf. That'll get you back in front of me, and we'll talk through, we'll work through those motions. And then ultimately, once I've ruled on the motions, if there are any, we'll be in a position to talk about whether you're going to trial or whether this case is pleading out. Does that make sense?
Yes, sir.
You got any questions?
No, sir.
All right. Mr. Adams, anything else on behalf of Mr. Way?
No, Your Honor, if Mr. Abadi would send me his information, I'd appreciate it.
Mr. Abate, I am noticing that this is not quite your garden variety murder. We've 3 victims. One, do you expect this case to stay as a non-capital murder?
Yes, Your Honor.
Okay. 2, is discovery ready enough that you think you can get something to Mr. Adams in the next few weeks, or is it still developing?
I think I can definitely get him initial discovery as soon as, I don't believe I saw his entry and opting into reciprocal discovery, but I'll look again today. And if that's been done, I will get him everything that we have and that he needs.
His entry was filed on the 17th, so it's fresh. It's 4 days old, but I'm looking at it right now. And he has opted in. So if you would get to him as soon as you are able, what you've got for discovery now, you guys can be off and running.
Yes, Judge.
All right, Mr. Adams, it's official. He'll get you the paperwork, and then you and Mr. Way can figure out what you're going to do next. Okay.
Thank you, Your Honor.
All right. You are free to go, Mr. Way. You are free to leave the booth. Appreciate your patience.
All right, thank you.
Yep.
Judge, with that, that completes my business. Now, the excuse.
Yep. Thank you.
You and Miss Nelson have a happy holidays.
You too. Do you get a holiday?
I'm gonna take Christmas.
Good. One day.
Maybe we'll hire some more people in the meantime.
Yeah, good luck with that.
Y'all have a nice day.
All right. So Lieutenant Dooley, for some reason, I am having trouble connecting with anything on 1 North. We've got someone who's been very patiently waiting in 1 North, but I've tried booth 1, booth 2, booth 3. I don't know if you guys have another game plan. I muted it. All I'm trying to do is unmute it, but I need to do that remotely, and the system won't connect with 1 North. Well, let me try booth 2. I tried 1 and 2. Let me try booth 2. 1 North, booth 2.
While you do that, I'll call IT.
All right, thank you. Oh, this may work. 1 North, booth 2, join. Let's see. Oh, 460. 460. Ooh, look at that. Can you move to booth 2? Please?
Awesome.
We're trying it out. Booth 2 looks happier.
Okay.
Let's see.
I don't know what it is. Last week it was booth 2 on 6 South, and 6 South just worked perfectly for you. But last week it was acting like 1. So I don't know.
Yeah. Let me see if I can find it. Now we've talked about it, but I got to find it. Booth 2. 1 North, booth 2. Here we go. More spotlight. There we go. Hey, sir, what's your name?
Kevin Omega Dorsey Senior.
Position 6.
Mr. Dorsey?
Yeah.
Great. All right. I found you on here. So you are charged with shoplifting, and this is a really, really old case. Looks like Ms. Green is going to help us from the state side, and Ms. Wood from the defense side. Ms. Wood, what are we trying to do today with Mr. Dorsey with this shoplifting from, oh, he's got some new cases as well.
Judge, we actually received notification that this probation case, it expired in September of this year. I believe it was Officer Smith who sent that notification. And so right now, the only thing that's holding Mr. Dorsey in is a bond order on the new cases. Just to let the court know, I had Jackie Patterson follow up with Georgia Works to see kind of what the holdup is, because that bond order was, I think, placed over the summer on his new cases in non-complex. And I'm not sure what's happened, but Georgia Works does not have a bed for him at the moment. So I've also reached out to Ms. Markowitz to see if she can try to get an amended bond order in the works on his non-complex cases, because that is the only thing holding him in currently.
Got it. I'm seeing that. So Judge Borski entered a bond in mid-August of this year for Mr. Dorsey to be able to get to Georgia Works, bunch of other conditions. But let's clear up our little piece first. Officer Brown, do you agree that probation has expired in the 15 SC case that's on our calendar?
That's correct, Your Honor, on 9/20/2021.
Great. Okay. And I hope there is no warrant from us that is keeping Mr. Dorsey in, but rather it's waiting for a bed at Georgia Works. Is that your understanding, Ms. Wood?
Yes, Judge.
Okay, great. So Mr. Dorsey, it's nice meeting you. I'd rather I meet you in different circumstances, but your old case from 2015 that is now in my division, my guess is it was a Judge Downs case way back then. It's closed out. You are not on probation for that anymore. You do have these two new cases that are indicted. And you've got a bond, but it's requiring you to get to Georgia Works. And I know that Georgia Works is full / there's the Omicron variant and things are complicated. Folks have not forgotten about you. It's just a tricky time to be in your situation where we need you to be in a program and not just out on the streets wandering around. Ms. Wood, does Mr. Dorsey have an upcoming court date?
Judge, he does. He is on another non-complex calendar. I believe it's the very first part of February.
Okay.
And I'm hopeful Ms. Markowitz can work her magic and maybe get something for him if possible, even before that.
Okay. We will do just that. Mr. Dorsey, do you have any questions?
Yes, I didn't hear the court date.
So you have for sure a court date in early February. You may see a judge before then, because that may strike you as being kind of far away. It's about a month and a half away. But Ms. Markowitz, who is a supervisor over all of non-complex on the public defender side, is going to be trying to figure out why Georgia Works can't come get you. And it may be that we get you in front of Judge Borski before then to try to figure out a different plan. Okay?
Yes, sir.
All right. In the meantime, you stay safe. All right?
Yes, sir.
Thank you, sir. Appreciate your patience. You're free to leave the booth.
Oh, one thing I wanted to ask.
Yes.
So I have been granted Georgia Works.
Ms. Wood, is the issue that he was not accepted into the program or that he's been accepted, but there's not room?
Judge, from what Jackie relayed to me, that was coordinated. He was accepted back in August, and I'm not sure what happened. Perhaps maybe we just didn't get him out in time, but there's not currently a bed for him is the issue now.
Okay. So yes, sir, you've been accepted in, but sort of like the manger in Bethlehem, there's no room in the inn right now. All the beds are full. And once there is a bed available, you're on that list to get one of those. Okay.
Yes, sir.
And Mr. Dorsey, if I may add very briefly, now that it's on Ms. Markowitz's radar that they're not accepting you right now, she may be able to find another place that's similar to Georgia Works. But you are on her radar, and so hopefully she'll be reaching out to you after the first of the year with an update. Okay.
Yes, ma'am.
Okay. Good luck to you.
All right.
All right. We have a couple other positions. We've got an Angelo Holt. He should be in 2 South. Are you with us, Lieutenant Dooley? Can we just quickly go over the calendar?
I actually have Holt on 5 North 600.
5 North. Okay. Let me see.
I need to verify the floor folder.
Okay. Yeah. 5 North is empty right now, but let me do, we got 2 other positions, although one, Position 7, the last name is NGOM. I don't know if he's in custody. It doesn't list a booth.
Yes, 7, 8, and 9 are not in custody.
Not in custody. So all that's left for you is Holt. If you can just tell me what booth to look in with Holt, we'll be good to go.
Supposedly 5 North. I'm calling right now just to verify he's up there.
Okay, great. Are you Kristen Kilpatrick? All right. If you don't mind sitting at one of the tables so you're in front of a screen so people can see you, go to that one. That'd be great. Mr. Whitenauer, are you ready?
Yes, Judge.
Great. Let me take the spotlight off here. Ms. Wood, we're going to handle position 8 right now.
Yes, Judge.
All right. So Mr. Kilpatrick is here. Is it for plea and arraignment?
Yes, Your Honor.
Okay.
That's correct, Your Honor.
Okay. Mr. Kilpatrick knows. So you're here for plea and arraignment. Oh, it says that in big bold letters. I just didn't see it. Ms. Wood, is Mr. Kilpatrick waiving arraignment and entering the plea of not guilty?
Yes, Judge, that is what Ms. Patel wished to do with this case. I will go ahead and fill out the waiver and get that to Ms. Nelson on Ms. Patel's behalf. I think we do need discovery in this case, and I also need a good number for Mr. Kilpatrick, so I can pass that along to Ms. Patel.
All right, we'll get that in just a minute. I'm pulling the case up as well. I'm curious, it lists a bond that just seems like a really low amount, but things happen. I'm just trying to understand. Looks like in April, Judge Richardson granted a $15,000 bond through the sheriff's 10% program. That's the correct math then for what I've seen. Mr. Whitenauer, anything you want to add in Mr. Kilpatrick's case at this point?
Your Honor, I would just note that based on my last review of Odyssey, I saw only one entry of appearance by Elizabeth Markowitz. And I was just wondering if we could just have an updated entry so that I can then serve discovery. And I would note if Ms. Wood, you could pass along to the PD who will be handling it. I would like to arrange a time to execute a search warrant for a buccal swab.
Okay.
So we'll do all that. Mr. Kilpatrick, Ms. Patel is your lawyer. Ms. Patel right now is not available. She's working hard. She just can't be here today. So Ms. Wood, who's her colleague, is covering for her today. So Ms. Wood's going to get a little info from you so that Ms. Patel can reach out to you once she gets the discovery from Mr. Whitenauer. Mr. Whitenauer, are you able to see folks on the screen there?
Sir,
good.
Do.
So Mr. Whitenauer is a prosecutor. He represents the state. Ms. Wood is the colleague of Ms. Patel. Just Ms. Patel can't be here today. I want to confirm your address to make sure we are getting notices to you since you are on bond. I've got an address of Abner Place.
2436.
Great.
Yes,
so that's home for you.
Yes, sir.
All right. Well, that's where you need to be based on your bond. If you're going to move, you got to get the green light from pretrial services because you are on intensive supervision.
Officer Gresham, by the way, is my pretrial. The officer I reach out to, I've been back and forth with her for about 8 months now.
Good. Well, so you've been doing well. That's a long time to be on supervision.
Yes, sir.
But stay in touch with Officer Gresham. The main condition of your bond is that you have no contact with Ms. Stevenson. So make sure that that continues to be the case. You've got an ankle monitor.
Yes,
we're paying for the ankle monitor. Curfew, sounds like you're doing what you need to do. So please keep doing that. Again, if for whatever reason you need to move from that Abner Place address, that needs to be coordinated through Officer Gresham.
Okay.
Who lives at Abner Place with you?
It's just me. I have a roommate also.
Okay.
Your Honor.
But it's a place where you think you're able to stay.
Yes.
Okay. Are you working?
Yes. I actually have I do a fleet wash. The company is called Fleet Wash. We wash trucks, do all kind of Publix, grocery stores and stuff like that. Before then, I was working with Mortar. Actual company is Gresham Transportation Services. They contracted through Mortar. But with this little incident had popped up on the background, they
just terminated me, but the general manager actually told me when I get it all squared away, I could come back because I was an excellent worker, Your Honor.
Okay, good to know. What is a phone number that Ms. Wood could give to Ms. Patel to track you down?
Okay, it would be 404-642-4351.
Thank you. And Judge, I can give him Ms. Patel's number as well if you'd like.
Yep. So you're able to take this down, Mr. Kilpatrick?
Yes, Your Honor.
All right.
All right, it's 404 it's 612
612
0734.
0734. And what's her name again, Ms. Woods?
Her name is Shamal Patel, Patel. And if she doesn't answer, just leave her a voicemail and she'll get back to you as soon as she can, okay?
Yes, ma'am, will do.
All right. So Ms. Patel, Patel. And Ms. Wood, when you file the waiver, can you also include the entry of appearance for Ms. Patel so that it is updated to show her rather than Ms. Markowitz?
Yes, Judge. Yes, Judge. I just sent that to Ms. Nelson.
Fantastic. Thank you so much. Mr. Whitenauer, anything else on behalf of the state?
Nothing from the state, Judge.
All right. So Mr. Kilpatrick, what's going to happen next is that Mr. Whitenauer is going to send discovery to Ms. Patel.
Okay.
Ms. Patel is going to arrange a time to meet with you so you all can look at what the state has, witness statements, police reports, video, who knows what. Something else that's going to happen, just so you keep it on your radar, Mr. Whitenauer is going to work with Ms. Patel. He's going to get a search warrant to get your DNA.
Okay.
They're going to put a little something in your cheek and get some epithelial cells. But if he's got a warrant to do that, Ms. Patel will let you know what your rights are and what they aren't in the face of a warrant. But she can guide you through that process.
Okay.
I just don't want you to be surprised if she reaches out to you saying, hey, an investigator is going to come take some of your DNA. If she says you need to do that, you should follow your lawyer's advice. Okay?
Understood, Your Honor. And
all right.
Your Honor, one question. With the job, I made talk to Officer Gresham about the situation, but sometimes my jobs, they want me to travel to Augusta, but she told me that I need to get a bond modification from the judge but you're a new judge on my case. So I was trying to reach out to the last job, judge, but
so what you need to do is reach out to Ms. Patel.
Okay.
Yeah, and what she would do is put together a little motion. She'd talk with Mr. Whitenauer. Mr. Whitenauer might have no issue with it, in which case her motion would say, no one has a problem with this. I'd likely say, okay. Mr. Whitenauer might have a real good reason to be concerned about it. And he'd get a chance to say, no, don't modify the bond.
Right.
But we would have that discussion with you present, or you could zoom in. But the way to tee it up is to reach out to Ms. Patel. She'll have a bunch of good questions for you. Well, how often do you go to Augusta? How long would you be there? Could we agree to a curfew? And then if she thinks it's a good idea to ask for the modification, she'll actually file something to modify the bond.
Okay. Understood, Your Honor.
All right. Great. Mr. Whitenauer, anything else?
Not on this case, Judge.
Great. That is it. Mr. Kilpatrick, you are free to go.
All right. You have a blessed one. Merry Christmas, you guys.
You too. All right. We have in 5 North someone. Let me activate that.
He's there.
Yep, I see him.
Okay.
Mr. Holt, can you hear me?
Yeah, yes, sir. Good morning.
Good morning. I'm Judge McBurney. We need to figure out what's happening next with your case. I'm going to pull it up on my screen here. Mr. Whitenauer, this is your case for the state?
Yes.
Yes, Judge.
Ms. Wood, is this yours or Ms. Patel's longer term?
Judge, actually, it's going to be neither of us. It's going to be Ms. Primovich's case.
Way to do the handoff. All right. Mr. Holt, you are represented by the public defender. We've got 2 really, really good public defenders in this courtroom. Ms. Wood is on the call right now. You're going to see her. Ms. Patel is the other. They have a supervisor, who gets involved sometimes as well, and that's the Ms. Primovic who is going to hold on to your case. Your case went into what we call judicial hold status back in October of 2019.
Yes.
It looked like you had a hold out of either Cobb or DeKalb or both. And I'm going to get out of the way now and let Ms. Wood tell me what she thinks is going on with your case, and I'll hear from Mr. Whitenauer, and then we're going to make a plan. Ms. Wood, tell me what's happening with Mr. Holt.
Thank you, Judge. So according to Ms. Patel's notes, this case was part of a big transfer a couple of years ago. It went from Judge Cox to Judge Reeder, and I guess that's how it's here. She noted that he had already been through a plea and arraignment in Judge Cox's courtroom. However, she understands if we need to do that again for this courtroom. She does have initial discovery and some medical records. And so I think the biggest thing was she wanted to make sure we got a case management scheduling order in the works. And as I did note, it will be Ms. Primovic's case. So I'll make sure to get an entry of appearance in on her behalf as well.
Okay. I followed everything you said. I'm just looking, there is not in the docket that I can find a waiver of arraignment, or maybe it was a formal arraignment, so it would have been in the events category. But Mr. Holt was indicted in September of 2018, and the next entry is a case management order from Judge Reeder in December of 2018. So it may make sense so that the docket is complete, and it would also make more natural the issuance of a scheduling order if you, on behalf of Ms. Primovic, Ms. Wood, entered a waiver of arraignment, and that would trigger the scheduling order, and we could move forward in that way.
Yes, Judge, I will get that together right now.
Okay. Mr. Whitenauer, you, like Ms. Wood and Ms. Primovic, are coming in a little later on in this case that has already aged a bit. Where is your case file? By which I don't mean is it on your desk, but from your review of it, does it seem like you've got everything you need to be trial ready, and so you can get all that to Ms. Primovic, or is there work to be done?
Judge, I'm working from home today, so I don't have the physical file here in front of me, but I have reviewed that physical file, and it does seem mostly complete. The one thing that I would add, Judge, is that this defendant does have other sexual assault matters in other counties. There was a CODIS hit in DeKalb from a 2005 case, and 2 CODIS hits out of Clayton County, one for a 2008 and a 2017 case. So I do need to obtain the police reports and evidence from those cases so that I can then file 413, and would be asking that the state be heard on those matters.
Okay, well, you'll have time to do that because, as I described, and Mr. Holt, I promise I'll explain all this to you as well in case you've got questions. You'll have time because we'll get a scheduling order in place in the next few days that will lay out when discovery is due, et cetera. And then you can just work with Ms. Primovic, get on her radar. There may be a few things that trickle in late because you're trying to pull police reports from many years ago from neighboring jurisdictions. And then the 413 notice you can file when it's ready. But we'll move this case towards a trial date consistent with the work that both sides need to do. All right, so to recap, Ms. Wood, you'll do the waiver of arraignment and the entry of appearance on behalf of Ms. Primovic. Mr. Whitenauer, you will get another batch of discovery to Ms. Primovic, make sure she's got what you've got, and then you're going to be working on some of this other acts evidence that you think is out there. And that leaves you, Mr. Holt. Do you have questions about what we've been talking about? What can I better explain to you?
Sure. Your Honor, I would like to just, this is the first time I really had a chance to speak to you, Your Honor, and I appreciate it. The case in Clayton County in
So let me, before I will hear you out, but let me just say this, because if I don't, Ms. Wood is gonna try to like unplug you from the call. You can tell me what you want. You are not helping yourself if you're going to talk about any of the facts of any of these cases. If you're going to simply tell me, look, it's a case, there's a warrant for me, or it's been dismissed. If it's procedural stuff, lay it on me. But if you're going to tell me, oh, the lady lied on me and it wasn't me, my uncle, don't do that. Okay.
No, Your Honor. I was just going to speak about the case in Clayton County, the 2000, I think that was 2008 case, Leona Lightburn. There wasn't, I wasn't charged with that. I was just went in for questioning, and one of the detectives did the investigation and found no probable cause for me on it. And he he told Ms. Lightburn as well, he closed the case out because there was no probable cause to arrest Mr. Holt. And that was in 2009. I think it was.
So I hear you. I'm gonna stop you only because the way the law works here, Mr. Whitenauer, as the prosecutor, is going to get all that info. He's going to make a decision. Do I want to explore that or not? But he could still decide to explore the Clayton case, even though Clayton didn't go forward with it. It is not a requirement that there be a conviction in some other situation for the state to try to use it as other acts evidence, as a similar transaction. That's something that I promise you, Ms. Primovic would argue. It's like, well, this is crazy. You know, Whitenauer is trying to use this thing where the police said no basis, no foundation. And I would weigh that. But Mr. Whitenauer is not limited to convictions that you have. He could find something that someone comes forward and it was never even reported to the police. He's interviewing a witness and that witness says, well, let me tell you something else Mr. Holt did. And if he believes he could prove it at trial, he could try to use that as an other act. And we're diving a little deeper than we need to right now, but I wanted to put your mind at rest that we'll work through that, but it doesn't need to be a conviction for Mr. Whitenauer to say, I may want to look into that. Okay?
I understand. I have one last question.
Yes, sir.
Okay. Am I going to have a bond hearing? I thought she said I was going to have a bond hearing.
It's a great question. I don't know where we are in that process. You and Ms. Primovic are going to need to huddle up on that. You may really want one, and she will work with you on that. And she may say, look, I'll have one for you, but you've got no chance of getting one. She may say, oh my gosh, you should have had one 6 months ago. But that request will need to come from Ms. Primovic. So what Ms. Wood is going to do is report back to Ms. Primovic about how today went. Ms. Primovic will meet with you, and that'll be your time to say, hey, could we please have a bond hearing? And Ms. Primovic, I know her well. She's going to say, sure. Let me tell you how it's going to go. You've got a great argument or you got a terrible argument, but it's my job. I'm going to throw it up there. We'll see if it sticks. Maybe Judge McBurney will give you a bond anyway. So today is not that day. That's not what this was. This was simply on the calendar to figure out where are we now. Mr. Holt has been in other jurisdictions. He's back, and we need to work through his situation. So if bond hearing makes sense to you and Ms. Primovic, she'll reach out to my staff. We'll get it on a calendar. Mr. Whitenauer will argue for the state. Ms. Primovic will argue for you, and I'll let you know what I'm going to do. All right?
Sure.
All right. You bet. So that's where we are. We'll look for that entry of appearance / waiver of arraignment. We'll get a scheduling order out, and I'll let everyone know this is a case I'm going to prioritize given its age, especially if Mr. Holt's status remains that he's in custody. Now, if he's in custody because he got convicted out of the cab and not going anywhere, that's different. But he's wearing a blue jumpsuit and not a red one. So that says to me that there's not a conviction that's holding Mr. Holt in. There may be holds elsewhere, et cetera. Don't know. And that's not what we're working through today. But this is certainly a case that we'll want to move as quickly as is consistent with everyone's due process. Mr. Whitenauer, anything else in Mr. Holt's case?
Nothing from the state judge, and I'd ask to be excused as soon as the matter is concluded.
It is. Happy holidays to you and yours. And Mr. Holt, you are free to leave the booth.
Thank you,
Happy
Judge.
holidays.
Judge McBurney, that's our last jail case. May I be excused?
Yes, Lieutenant, thank you. Went real smoothly today. Appreciate it.
You're welcome. Happy holidays, Merry Christmas.
You too. So we only have one case left. Someone did walk into court. Are you Mr. NGOM?
No, sir.
All right. Ms. Wood, did you have any sense that Mr. NGOM was coming to court?
Judge, unfortunately, the numbers that we had for him are not current working numbers, so I have not been able to speak with him.
All right, let me look at the case in Odyssey. 647. So he got a signature bond. Don't think you're supposed to get with those charges. In June, maybe in June of 2020, you could issue a signature bond like that. But then, yeah, so he bonded out in June of last year and was indicted in November of this year. So almost a year and a half passed. And he didn't need to come to court for anything. Ms. Green, do you have any requests or info about position 7?
I don't have, am I muted? Let's see.
You're not muted. We heard you.
Okay. I don't have any new information, but I get the state would need to request a bench warrant for his appearance as long as we have service on him.
Okay. So this gentleman is 71 years old and is from Dorchester, Massachusetts. Not quite sure why he was in Atlanta at the time, but his phone number is from Massachusetts. He's got an address in Massachusetts and he's 71. Just playing this out in my head as to what it's really all about. Let me look at the indictment. He allegedly pointed a knife at someone. All right, I'm going to ask you, please, Ms. Green, to have Ms. Charles and her investigator try to contact the victim in this case. And I'm going to give the state 30 days in which to contact the victim. If you all are able to connect with the victim, then I will issue a bench warrant in this case. If you're unable to contact the victim, then we may just move this case over to judicial hold, but without a bench warrant.
Understand, Judge.
And we'll see what that yields. Ms. Wood, any objection to that?
No, Your Honor. Thank you.
All right. I think we're done, but I'd ask you both to stay on. Someone has come into court. Sir, you are here for what case?
It's about a decision made a couple of weeks ago.
Okay.
On my case. That's what I want to talk about.
Well, all right. And your case, is it a criminal case or a civil case?
Civil case.
All right. Well, then I don't need to keep these other folks on, I don't think. Ms. Wood, anything else?
No, Judge.
All right. Ms. Green, thank you again for filling in. Where's your normal home?
I'm in Dunaway.
Oh, you poor ADA. I'm sorry about that. Oh, well.
Dunaway.
Someone has to.
Do I not look familiar to you, Judge McBurney? No.
Well, you're on a really, really small screen, so I bet if we were in the same room, I would say, "Oh my gosh, how are you doing?" But
In a defense attorney in civil practice, so I appeared in front of you like a few interpleader actions.
Really?
Representing the sheriff a while back. Yeah.
And now you're with the DA's office. Welcome aboard. How long have you been here?
I've been here since March.
Well, that's fantastic. And how long have you been stuck with Judge Dunaway?
I just got assigned to Judge Dunaway.
Well, good luck with that. He's a good guy. He and I worked together at the DA's office a million years ago. And that'll be a good spot for you. I'm glad you are. Were you in a trial division before, or you moved from one of these invisible units to the trial division?
I went from invisibility to visibility. So I came in at the very bottom and worked my way up because I'm new to being an ADA. So I was in juvenile, I was in, I guess they call it case intake now. And then I skipped over the non-complex sector and now I'm in complex.
Excellent. Well, good for you. Enjoy it with Judge Dunaway. Maybe someday we'll get you over here to 8 Delta. It's more fun on the 8th floor than the 4th floor anyway. So, but have a great holiday. And if you would please let Ms. Charles know what we're doing with the cases you help with.
Will do. Thank you.
All right. Take care.
Thank you, Judge.
Thank you. Ms. Rivers, thank you so much. We'll see you in drug court tomorrow.
Okay, Judge. See you in the morning.
All right. Thank you, Officer Brown.
Thank you. Happy holidays.
You too. All right.